In this segment, we discuss the trust estate, master transfer and assignment of assets, which looks like this. Though we strongly emphasize how important it is to formally title your assets in the name of your trust, it still makes sense to execute backup documents in case one or more assets are not in the trust at death and there is no other way to gain control. This master transfer is one of those documents. The pour-over will is the other. Problem is, having to use either of these documents to gain control generally means going to court. For that reason, neither is a good substitute for formally titling assets in the trust, yet it is still important to have them as a backup just in case. The master transfer and assignment of assets to trust is the first-level backup. It is a general declaration that you presently assign and intend all of your assets to be a part of your trust, including, but not limited to, any and all real estate, bank accounts, stocks, bonds, partnerships, sole proprietorships, patents, household and personal effects, and all assets and property of every kind, except qualified retirement plans. This master assignment should never be viewed as a substitute for actually titling all of your individual accounts, real estate, and other assets in your trust. Rather, it is only intended as an emergency backup between now and when you are able to formally title each asset in your trust. If something happened in the meantime, this document could be used to argue that such accounts and assets were part of your trust. In California, for example, when someone has passed away with assets not titled in the trust, you can use this document to file what is known as a Hegstad, or 850 petition. The good news is that California courts almost always honor this document, meaning they will generally issue an order confirming any untitled assets as part of the trust. Also, filing these petitions is far less involved than full probate, and thus are generally much better than having to use the pour-over will. The bad news is that filing a Hegstad petition still means going through the expense, time, and hassle of a court process, the very thing you are trying to avoid. Further, there is also no guarantee that other states will be so accommodating or accepting of this document. That is why it is always far better to title each asset in the trust while you are alive. That is, to truly change the record of ownership of each property, account, and asset so that everyone's records reflect titling in the trust. This puts everyone on the same page and will eliminate any argument as to whether or not the asset is part of your trust. This means, at your death or incapacity, your successor trustee will generally be allowed instant access to such assets without the need for any court proceedings or waiting periods, such as those required with small estate affidavits. If you haven't done so already or need a refresher, be sure you have reviewed and understand the importance of titling assets in the name of your trust. It is the very key to making your trust work the way you intended and taking full advantage of its potential. As with most of your documents, you should sign and date your master transfer document right away. As is also true with most of your documents, you should also have it notarized as soon as possible. But remember, you do not need to sign in front of the notary and the date of the document, and the date of notarization do not need to be the same. Before leaving the notary, always make sure they have stamped, signed, and completed all parts of the notary acknowledgement area. Once the document is both signed and notarized, the signature and notary area, it should look like this.